Good evening, ladies and gentlemen. Thank you all for coming to this academic panel discussion hosted by LULSA, BALSA, NALSA, NLG, and Los Abogados. The goal for this evening is for each of us to leave here with a better understanding of how Arizona's legislation falls into the context of Supreme Court jurisprudence and constitutional framework. Before I introduce our esteemed panelists, I'd like to remind everyone to turn off their cell phones. Please go now. And also, as the president of LULSA, I would like to encourage everyone to be respectful this evening of diverse opinions. So please be mindful of that. Here we have Attorney General Tom Horne, who used to be one of the superintendents. He's one of our panelists. To his right is Professor Atwood, who is our moderator this evening, and she teaches civil procedure here at the law school. Then we have civil rights attorney Richard Martinez, who is the lawyer representing the TUSD high school teachers. And then we have Professor Spece, who is a common law scholar. So before we begin with the questions, Professor Spece is going to give us an introduction of constitutional law for those of you who are not law students and have not yet taken those courses. But if you have any questions, there are index cards at the end of each table. And I ask that questions from the audience wait until the end, and we'll come collect the questions from you and give them to the moderator to be asked. But without further ado, here's Professor Spece to give us an introduction. Thank you everyone for coming this evening.
Well, I'm not going to attempt to give you a background of all constitutional law, but maybe some of the educational law that applies to this context. And it is a unique case, and I'm basing my analysis on the pleadings which I've had access to. Putting this in historical perspective, the first compulsory school attendance law was passed in Massachusetts in 1852. In the early decades, school law consisted of interpretations of state constitutions and statutes. And it should be pointed out that to this day, school boards are afforded much discretion, especially regarding curricular matters. There wasn't a great involvement of the Supreme Court of the United States until after Brown versus Board of Education. And let me just pause to stop there. Brown stands for the proposition that if educational decisions are taken on the basis of race and harm a racial group, then they are unconstitutional as violating the Equal Protection Clause of the 14th Amendment. If the pleadings in this case are correct, there is action here that seems to be intentionally directed at a particular racial group to their detriment, and if so, it would violate the principles of Brown and its progeny. Now, although I said the Supreme Court wasn't involved that much in school law until after Brown, the foundation for the current constitutional framework was established by three cases in the 1920s. First, 1923, Meyer versus Nebraska. This struck a prohibition on the teaching of foreign language until one was 14 years old. And this was based on the Due Process Clause of the 14th Amendment. In 1925, Pierce versus Society Sisters, based on the same provision of the Constitution, struck a prohibition on private schools. And finally, in 1927, in Farrington versus Taguchi, the court struck a prohibition on foreign language schools in then what was the territory of Hawaii. And there were such requirements as the instructors must be possessed of the ideals of democracy, knowledge of American history, and teach Americanism. They could only teach 1 hour a day. They had to pass an audit of bureaucrats. And the Supreme Court said, we won't look at each provision, but as a whole, it's an obvious attempt to foist an orthodoxy on an entire people and was unconstitutional as a violation of substantive due process. And the court cited Meyer and Pierce. Now, these three cases all dealt with a national effort, which was overt at the time. to inculcate white Anglo-Saxon Protestant values on a nation, with no question that we were pervasively a Christian nation. This was implacable orthodoxy. Numerous relevant cases post-Brown involving a complex of esoteric doctrines and precedents exist. The best one could do, especially in this short time, and let me know if I go over because I'll have to cut it short, is tease out a few threads from cases. My bottom line is that we've gone full circle. We're back to the 1920s. We're back to the attempt to impose orthodoxy on an entire people. And if I look at the face of the statute, I don't even need to look at the pleadings, it has the following hypothesis. If one advocates ethnic solidarity, then one is not treating pupils as individuals. In other words, it's un-American, it's improper, and it should be illegal to teach ethnic solidarity. But I would say that one of the great principles of our diversity in our nation is to encourage diversity and to learn from each other, not to stamp out opposing viewpoints. Let me look at some of these cases. West Virginia versus Board of Education versus Barnett in '43. You can't force a child to take a flag salute because you can't force them to embrace ideals promulgated by the government. And this was based on freedom of speech, not religion. Another case, Tinker versus Des Moines Independent County School District, 1969, striking the ban on wearing armbands in protest of the Vietnam War. And Justice Ford has famously said, it can hardly be argued either students or teachers shed their constitutional rights at the schoolhouse gate. In our system, students may not be regarded as closed-circuit recipients of only that which the state chooses to communicate. When he is on campus during the authorized school hours, he, the student, may express his opinions, even on controversial subjects, if he does not materially and substantially interfere with the requirements of appropriate discipline and without colliding with the rights of others. Another relevant case, Board of Education versus Pico, decided in 1982. There, a plurality of the court stated that school board officials cannot order removal of books from public school libraries because of a narrowly partisan or political ideal. Next case, U.S. versus American Library Association. There, the court upheld the requirement of installing filters to screen out pornography in public libraries that accepted federal funds to get the computers that were being used. But the court said that if the nature of the institution involved requires one to oppose government or to bring up diverse ideas, citing the Velasquez case where the government attempted to prohibit public interest lawyers from attacking the government, the court said you can't stifle that. You can require the filtering out of pornography, even though you might have some overreach and overkill. Next case, Ashcroft versus Free Speech Coalition, striking as overbroad a prohibition on virtual child pornography. In other words, these weren't actual children, these were virtual children. And the government argued, well, we need to reach this legal communication so we can stamp out the illegal. And the court vehemently protested against that and said, you can't attack the illegal by, in our society, screening out the legal. Morse versus Frederick in 2007, you can prohibit speech advocating illegal use of drugs as was interpreted by the principal involved. But it's important because since this is a unique case, politics and precedent will have a unique sway. And it's important to look at the justices of the court. In that case, Justice Roberts himself was unwilling to accept the government's argument that any profane speech in the schools should be disallowed. He said that is overreaching, the government's overreaching. But in concurrence, and this is important, Justices Alito and Kennedy concurred and said, we allow the stamping out of advocating illegal conduct, but we do not accept the idea that students can be restricted in any political or social communication and ideas. So in a second, I'd like to look quickly at the lineup of the court and how they might go on this. Final case, Lavelle versus Griffin, 1938. Striking a prohibition of the distribution of leaflets by a Jehovah's Witness or anybody unless they obtain written permission of the city manager. The reasoning, you don't have to show that the city manager abused the discretion. You don't have to show that this particular plaintiff's speech was curtailed, but the mere possibility of censorship was anathema. There, summing up, I would say this law gives the official tremendous discretion, which would be inconsistent with cases like Lavelle. If one looks and parses the threads of these cases together, invades the institutional and derivative rights of the local school board to have a diversity of ideas rather than be forced to foist an orthodoxy on the students in Tucson, Arizona, as was attempted to be done back in the 1920s.
Thank you. I want to welcome everybody as well. I second also the sentiment that this is a time for a very respectful discussion. I'm so excited to see such a crowd here, and it shows the intense interest in this issue. And I know that a lot of you feel passion about it. And it's a time for a discussion where I hope that you'll learn a lot about the constitutional backdrop to the whole dispute. And incidentally, for those of you who are not law students and you enjoyed what you just heard from Professor Spece, sign up for law school, because that was, very similar to what you might get in a con law class. But I thought I would turn now to Attorney General Horne to explain why that constitutional law framework doesn't support the lawsuit that we're here to discuss. In other words, why are those cases that Professor Spece mentioned not applicable to protect the Mexican-American Studies program here in Arizona?
Thank you. In consideration of the people in the back, I'll stand, although I'm having problems with the microphone here. Now, the invitation for people to sign up for law school, I take it you have open admission now.
No, not quite.
And they can just sign up. Well, I would like to start out in emphatic agreement with the first principle that the professor stated. And that principle was that educational decisions based on race are unconstitutional. I agree with that principle emphatically, and I believe that we can take that principle as a foundation for all further discussion. Educational decisions based on race are unconstitutional. Where I think we have a disagreement is in a philosophical question which, in my opinion, goes to the most profound philosophical questions before us, and that is, what is it that's important about a human being? It is my belief that what is important about a human being is what does he know, what can he do or she, what is his character or hers, and similar kinds of individual questions, and not what race that person happened to have been born into. And I believe that that is a fundamental philosophical principle that underlies the belief system of the United States of America and its Constitution. And that based on that principle, we didn't even need this statute. That the ethnic studies program was already unconstitutional under this principle that the professor and I totally and emphatically agree on. People are individuals. They are not exemplars of a racial group. And in my view, what race you happen to have been born into is completely irrelevant to anything in school, in society, in the courts. As President John Kennedy said, race plays no proper place in American life or law. In the summer of 1963, having just graduated from high school, I participated in the March on Washington, in which Martin Luther King said, and we all remember it since then, "I dream of a day when my son will be judged by the content of his character and not the color of his skin." And that has been fundamental to my belief system my entire life, and I believe it is fundamental to our Constitution. Now, what we have here is a situation, we're talking about the public schools. And I believe that it has been a fundamental purpose of our public schools historically in this country to take students from different backgrounds, to mix them together, and to teach them to treat each other as individuals. The Ethnic Studies program in the Tucson Unified School District does just the opposite. It divides students by race. Now, I'm fully aware that none of the courses are exclusionary and that you can go into a course if you don't belong to that race. But the numbers of people not of that race are very small. The courses are primarily divided by race. So we have Raza studies for the Latino kids. We have African American studies for the African American kids. We have Asian studies for the Asian kids. We have Indian studies for the Native American kids. It sounds just like the Old South that I fought against back in the 1950s and 60s. Only now this kind of new racism is being promoted by the left, whereas the old racism was being promoted by the right. But dividing students by race is racist no matter whose ox is being gored, no matter who's doing it, no matter who claims to benefit from it. If you divide students by race, it's a racist program. Now, in the standards, and as you know, I was the superintendent of schools, in the standards promulgated by the state of Arizona, it is required that all students learn about the contributions of different cultures. America has been enriched by the contributions of different cultures, emphatically including Hispanic culture, which I am a serious student of. I have been seriously studying the Spanish language for the last 3 years. I do my interviews on Univision in Spanish. I read Mexican history and Spanish books. I believe very strongly in the contributions of different cultures. But what we require in our school system, and I'll explain in a moment, we have a right to require in our school system, is that we teach students the contributions of different cultures. We don't divide them up and then teach each group only about its own contributions. School emphatically is a place to broaden horizons, not to narrow them. And to take students and divide them up and say, you are in this race, therefore you should be in this class, and we're going to teach you only about the contributions of that race, is, in my view, not only contrary to this statute, but unconstitutional under the very principle that the professor said, which is educational decisions based on race are unconstitutional. And public schools in the United States of America in the 21st century have no business dividing up students by race. We should have gotten over that at the time of Brown versus Board of Education, and it's one of the profound ironies that the left side of the political spectrum in the United States today is advocating the division of students by race and teaching them only about their own race, instead of using schools to broaden their horizons, to learn about the contributions of all different races, and to teach them to treat each other as individuals. And that's where we get into the statutory provision that says we should not be teaching ethnic solidarity. Ethnic solidarity is a racist concept. We should be teaching students that we're all individuals and we should all respect each other as individuals. If you tell me that somebody is Hispanic, you have not told me anything important about that person. I want to know what he knows, what he can do, or she, what is their character, not what race they were born into. Now let me just give you, you say time, I just want to, before I finish, if you give me just 1 minute,
Yeah.
I want to do two things. First of all, I want to read you a passage from the curriculum so you know what we're talking about. And I'd love to hear the professor's comment on this. And I have a lot of them, but I'll read only one short one in view of the time. And second, I want to say a brief word about the right of the state government to set curriculum in our schools. In the class, they use a field guide for achieving equity in school. This material states the following. We often hear people referred to as being privileged, which usually is a comment pertaining to the individual's financial or economic status. In courageous conversation, that's what they call this, courageous conversation. However, privilege takes on a different meaning. It refers to the amount of melanin in a person's skin, hair, and eyes. This is followed by a table which promulgates racial stereotypes by detailing the differences between what they call white individualism and colored group collectivism. Listen to this racist language, white individualism and colored group collectivism. White people tend to dominate the conversation by setting the tone for how everyone must talk and which words should be used. All of these white ways must be recognized, internalized, and then silently acted on by people of color. The aforementioned white cultural characteristics, such as individualism, blur into the consciousness of whites, which becomes not only a way of behaving, but also a way of thinking. White people depend on the overwhelming presence of other white people in positions of power and influence to maintain a system of racial advantage. At the same time, many white educators believe that gains in school, as in their own lives, come from individual effort and accomplishment. I want to ask, how many people here believe in these generalizations about white people? Raise your hand if you believe in these generalizations about white people.
White privilege?
No. That white people dominate the conversation, white people, well, that is, it's very interesting. You see the effect of ethnic studies. You can see it. You can see it. Because white people and all other people are individuals. Some of them think as individuals, others think collectively. You cannot tell how somebody thinks, those of you who raised your hand, about individuality or about collectivism or about racial advantage or what gains come in schools. You don't know that by knowing their race. I know a number of Hispanics who are much more conservative than I am. You don't know anything about somebody by their race. And this curriculum is promulgating a racist philosophy that tells you that what's important about people is not their individuality, but their race. One final point, and that is on the right of the state to set curriculum. Under our system, the state sets standards. And under those standards, schools are held accountable. If they don't teach the standards, they can be subject to sanctions. So, for example, if we say you teach algebra in the 10th grade, and instead of teaching algebra, the students are taught arithmetic, and the kids can't pass an algebra test, the state has a right to sanction that school district, including withholding funds. The state has made a determination that in the curriculum of the public schools in Arizona, we are going to treat people as individuals, and we are not going to teach them to treat each other on the basis of their race. That is entirely within the rights of the state of Arizona in its public school system. Thank you very much.
Thank you, Attorney General Horne. I assume that Richard Martinez doesn't agree with what you just heard, and we'll turn to him to explain basically what his lawsuit is maintaining, focusing on why HB 2281 is unconstitutional itself in its targeting of ethnic studies.
Let me start with the last thing that Attorney General Horne said. And I think that that provides the starting point for what is a fundamental difference between the way he sees America and the way I see America. The way he sees the Constitution and the way I see the Constitution. The way he sees the diversity of this country and the way I see the diversity of this country. It's fundamentally different ends of the spectrum. He talks about a government. He says the state can dictate and issue the finding he issued. I'm sorry, the state didn't issue a finding. one person did. One person who was in a position to exercise power from his own personal perspective. Tom Horne, hours before he was sworn in as Attorney General, signs for all of us a finding saying that ethnic studies, Mexican American studies, and TUSD is a non-compliance of HB 2281, a law that he promoted, that he advocated for, out of his own personal offense to this curriculum. He abandoned his respective local control of our school board. He exercised the decision that he leaves on the hands of his successor, Mr. Huppenthal. And he, even as a lawyer, violates one of the most fundamental principles that exist. He issued a finding based on conduct exclusively that occurred prior to the statute even becoming effective. It's an ex post facto law. His finding certainly is an ex post facto finding, and they know that. They tried to tell us, essentially, you can't go on the freeway in excess of 75 miles an hour when the law said you could go 80. That's one of his big problems. It is, we have in law a war going on. It's a cultural war, and it has to do with a battle over the Constitution. How do you interpret it? Who does it protect? It is a breathing, living document. Is it something that evolves with time and incorporates all of us and the circumstances that arise over time? Or is it a document that you go back to some fundamental interpretation of what it meant by the, quote, founding fathers? And even then, in Mexican American studies, see, they teach in that classroom, well, who are the founding fathers? Are they the founding fathers from the 13 colonies? Or are they the founding fathers of all of the United States? Are they the founding fathers that are limited to those that were at Plymouth Rock? Or are they the founding fathers that include those that came in to the Southwest? Does it include those that were the Native Americans who were here originally? You know, one of the books that Mr. Horne has pointedly taken offense at is Occupied America, a book that has been around for over 40 years, standard college text. Dr. Acuna is a product of our university, published by our university. And if you look at his book, one of the issues that has come up that Mr. Horne takes exception of, and I just want to offer this as one small exception, is the right to look at different events in our country and have a debate about them, and have different perspectives and allow students to think critically, to make their own decisions, and then to walk out and formulate their own belief system. See, his difference, the difference between his America and mine, is that in my America, I think you get to pick what you believe because you have developed critical thinking skills that have led you to a conclusion that is grounded in facts and critical analysis. My America doesn't say you take a position based on some dogmatic conclusion, some orthodoxy. I'm willing to take on the warts of our country, and not for the purposes of tearing down our country, but for the purposes of us going forward in a more enlightened way. That's what our Constitution is about. That's what our Constitution has always been about. That's what this case is about. We talk about the issue of race, and let me close on that. Educational decisions based on race. That's not what Brown said. What Brown said and what the right has taken away from us is this notion of a colorblind society, because they want to take that, and if you look back to the original founder, the person who promulgated that thought, as it came up in the post, excuse me, in the pre and post Civil War era, the notion of a colorblind society was taken on at the time of the Civil War, and it was taken on to try and deal with the issue of slavery. And if you remember our Constitution that we all feel so strongly about, our own founding document said that African Americans weren't equal. Our own founding document didn't even recognize Native Americans as citizens. We are a country that has learned from our mistakes and continue to make mistakes, but continue to have the opportunity to learn. Race, is this curriculum talk about race? Certainly does. It talks about race not from the context of superiority. It doesn't talk about it from the context of one is better than another. But I will tell you that in closing, the difference between the two Americas that Mr. Horne and I are talking about is, see, I think that we have a country that allows us to embrace who we are, to revel in it, to be proud. My father was what is now called by the Republicans in the legislature an anchor baby. My grandparents were undocumented. They were in Los Angeles, and my father was born by chance, or maybe not by chance, in LA County. Made him a United States citizen. Shortly thereafter, my grandfather was deported. So the family returns to Mexico, and he grows up in Guadalajara and then in Nogales. At the tender age of 17, he's knocking at the door saying, oh, by the way, I have the documentation show I was born in the United States. I'm a citizen. I'm returning to my country of birth. By our 14th Amendment, it's his country of right to be in. He returns just prior to World War II, and he spends his life here as a proud Mexican, but as a contributing, hardworking leader in this state, giving his all to the day he died about bringing all that he had to give. Because what Mr. Horne fails to recognize is that for Mexicanos to be proud of being Mexicano, and for every group, doesn't mean you're not proud of being part of this country. It doesn't mean that if I retain my language, it doesn't mean that if I retain my language, my culture, my history, my art, that I am doing it to the exclusion of anyone. I want my sons and my daughters and my grandchildren to be able to pick up the beautiful North and understand that story just as much as I want them to pick up any other novel or work of nonfiction that may be taught in our schools. What we give to this country to each other. See, I want my son to know about Tuskegee and the intentional infliction of syphilis and untreated. I want my son to know and my daughters to know about the rounding up of the Japanese and to be able to think about, well, why were the Japanese rounded up in World War II and not the Germans? I want them to know about the cycle of deportations of Mexicans, that we're welcome when the labor is needed, but when the economy turns sour, please leave. Not to build resentment, but to understand the dynamic. And fundamentally to understand that if you don't become citizens, if you don't vote, if you don't get the leaders in place, you end up with the one person who thinks they are the state and they can impose their will on all of us. That's what this lawsuit challenges.
Thank you, Richard. I think when you have the term racist used, it's quite inflammatory. It's such a loaded, strong term, and it's being used actually on both sides in this debate because Attorney General Horne views the ethnic studies programs themselves as racist. We just heard that. Richard Martinez's lawsuit is saying that the law that was passed targeting the ethnic studies program is itself racist. And in some ways, those labels, I think, don't encourage conversation. They're so strong. But what I'd like to ask Attorney General Horne is whether he agrees that for many, many years in this country, the teaching of history, social studies in the public schools was, in a sense, an ethnic studies program, but it was white ethnic studies because there was a lot that was left out. And whether this is simply an effort to fill in and to speak to the students in the way that Richard Martinez was talking about, to give all students a sense of pride in their heritage. Is that something we should be worried about?
Yeah, I agree that history at one time left out the contributions of many groups. And if you look at the standards that we promulgated from the Department of Education, which I was integrally involved in, you will find many performance objectives that require all students to learn about the contributions of different groups. And you can go online at azed.gov and read the standards, and you'll see the performance objectives there that require that all students learn about the objectives of different groups. I am also in favor of students learning different viewpoints that will cause them to think critically. I'm passionately in favor of that. I've been a strong proponent, for example, of the Ares series of history books, which present in each volume different essays taking contrary views about the same issue. I think that's a great way to teach kids, and I'm all in favor of learning substantively all the things that have been mentioned on the other side. But what you don't do in the United States of America is divide students by race. That is what I contend is racist, to divide students by race, to say, you're African American, so you go in that class, you're Latino, so you go in that class, and teach them only about their own contribution. That's what's wrong. And it's not true that the curriculum just teaches pride and doesn't teach resentment of other groups. I pointed out they told people that white people are individualists and colored people are all group-oriented. That's right here in the curriculum. A totally racist generalization that does not recognize the fact that individuals are different from one individual to another. The curriculum has something called critical race theory, in which I quote directly from the curriculum given to the kids. Unlike traditional civil rights, which embraces incrementalism and step-by-step progress, critical race theory questions the very foundation of the liberal order, including equality theory, legal reasoning, enlightenment rationalism, and neutral principles of constitutional law. I'd like to ask my two friends here to tell me what's wrong with legal reasoning, enlightenment rationalism, and neutral principles of constitutional law.
I'll rephrase that question. For Richard Martinez, why isn't it enough? If we have a curriculum that will, in fact, do a lot more than we used to do, teaching students of all ethnicities and races about individual groups' contributions, why isn't that enough? Why do we need a separate ethnic studies program itself?
Let me answer that in two ways. Let's look at the public schools and what our legislature has done in Arizona. We have embarked, as no other state has, on charter schools. When we did desegregation, because Mr. Horne said he was interested in the principles of Brown versus Board of Education. If you remember Brown, Brown's about desegregating. And you remember the reaction to Brown across the country? It was violent, it was visceral, and even in Tucson, Arizona, in 1980, just as in Phoenix, which is a much more segregated city from its inception than the way they did school district boundaries there, it reacted violently against integration. He's talking about something that in charter schools, if you look since the inception of charter schools to public schools, we have gone in the short span of time to the most segregated public schools the state has ever known. If you want to integrate the schools, Mr. Horne, then undo charter schools. Because what charter schools has encouraged and allowed, it has been legal white flight. And that's what it's been. Because we have gone to a school system in Tucson Unified School District that is now over 70% minority. Tucson's not 70% minority. It's 63% Hispanic and will soon be 70% Hispanic. We are more segregated today than we ever were before the Fisher-Mendoza lawsuit. Think about that. We are more segregated today than we have ever been. We get accused of having an education based on race, or that we only encourage students of one race into the class. Look at where our students are, our classes are. We're at Pueblo, well over 90% minority, primarily Mexican. We're at Tucson High, we're at Choya, we're at Rincon, we're at Palo Verde. Those are high schools that are highly segregated, but students of all colors are welcome into the class. Welcome into the class, welcome into the opportunity to learn and share, not just about Mexican history or Mexican perspectives, but from all perspectives, to be critical thinkers. You know, Brown talked about the notion that Justice Marshall was such a champion of before he ever got to the Supreme Court. And remember something too. Today, because of the politics of our country, Justice Marshall would never get appointed to the Supreme Court. He'd never be there. Imagine that voice not being a part of our legal history. And what we have in ethnic studies, Mexican American studies, is that I think some people request us to be an apologist about what it teaches. And I reject that. There's nothing to apologize for. It is something that needs to be fought for, and it is something that needs to be defended. And it needs to be defended in the courtroom within the confines of the legal challenges that are there from the constitutional challenges. Denial of equal protection, a denial of due process under the Fourth Amendment because of the void for vagueness issue, because no one, Mr. Horne, could define what it is that that statute's supposed to allow or not allow. And it is a law that violates the First Amendment rights of teachers, of students, of parents, and of the community.
I have a question for both Attorney General Horne and Richard Martinez, and it is a suggestion that's been floating around in the last few weeks, and the question is a compromise, an acceptable compromise position, making American history the foundational course in a school like Tucson High with ethnic studies classes being offered as an elective? Would that be something that you would find acceptable?
In the findings that I issued, I focused on the fact that I believe it's unconstitutional to divide students by race. That's the key to me. So from my standpoint, minor adjustments in the curriculum don't solve the problem. Now, it's not my decision to make. John Huppenthal is the superintendent, and it'll be his decision to make. And our decisions, by the way, are not unilateral the way my friend here described them, as though one person makes all the decisions. It's subject to an appeal to an administrative hearing officer and subject to process. It's not a one-person decision. But the fundamental issue to me is the issue of dividing students by race. I believe, I'll confess to this, I think there was an implied criticism. I believe in the colorblind society. I believe in the colorblind society, and I believe it is an integral part of our Constitution. Not the Constitution that was originally written that had references to slavery and so on, but the 14th Amendment, which tells us we cannot discriminate on the basis of race, religion, and so on. The 14th Amendment is a part of our Constitution. And the 14th Amendment tells us, as John Kennedy said, race plays no proper part in American life or law, and American public schools have no darn business dividing students by race. That's the fundamental issue. That's the issue that relates to the very first legal principle that we agreed to, which is that educational decisions based on race are unconstitutional. It is unconstitutional, in my opinion, to divide students by race in the American public schools in the 21st century.
Richard, do you have a stand on whether making the ethnic studies an elective is a compromise that would be acceptable?
Taking Mexican American Studies and turning it into elective, I think, is a fatal blow. It ends the program. And it ends the program in many ways, and I also think it has a discriminatory impact with a discriminatory intent behind it. Why should those students who want to take Mexican American Studies not have that class count towards graduation with respect to their English credit? Why should it not count towards their history credit in their junior year? Why should it not count towards their government credit in their senior year? Why is it that if we are going to take, any student is going to take Mexican American Studies classes, they have to do it as something extra as opposed to being a graduation credit? That is treating students differently and treating the curriculum differently. And I believe that it is the same kind of message that creates a second-class status. A second-class status that is unacceptable and been rejected by women, that is rejected by people of color, and by anyone who's been relegated into that role. So no, I don't accept that. The notion that keeps coming back to that we divide by race. If we divide by race, it is only because students choose to continue to attend a public school that is segregated because it's the only school available to them, and then they make a choice to come into, on their own or with their parents' involvement, into the Mexican American Studies class. We don't direct them. We don't force them. And that you get a higher percentage of students who are Latino in a Mexican American Studies history class or American history from the Mexican American perspective, I don't think that's surprisingly something phenomenal. Is that an act, a de jure act of discrimination, an intentional act of discrimination? Of course not. And Mr. Horne knows that the Supreme Court long ago rejected de facto segregation. If we were into de facto segregation and correcting de facto segregation, we wouldn't have the housing patterns we have in this country. If we were into enforcing as unlawful de facto segregation in schools, we wouldn't have the segregated schools we have today, because then Milliken wouldn't have been decided the way it was, and Detroit would have been desegregated, and it wasn't. So, you know, you play fast and loose with constitutional concepts that our Supreme Court has rejected because they went to a certain line and then backed off. That's the reality. We went and like to say we're about integration, but we're really not, because we're not yet comfortable with it. It's like many other debates in this country. We like to talk about, we want to integrate other groups. We want to accept a new definition of marriage, but we really don't. You know? And it is only when we make those fundamental changes in our country, which we will, but sometimes we get tired and impatient with waiting and waiting and waiting for that change.
I'll give you a chance. Yeah. We're moving into the period where I have a lot of questions that have come in from the audience in front of me. And since we don't have a huge amount of time, I'm going to combine a couple of these. It's just looking at them, it seems that people are interested in hearing why this is not an example of a very oppressive government imposing a kind of censorship on a school curriculum where the school itself very much wants to continue doing what it's doing. The students want to have the program, the parents want to have the program, but the state is telling the school that it can't. Is that, so the questions are saying, should we know, don't we have a First Amendment right to hear and teach what we want? Is this the beginning of ethnic cleansing is one question that's in front of me. So I think, Attorney General Horne, I'm sure you have a response to that kind of question.
Well, would it have been okay in the Old South for them to discriminate in favor of whites if the teachers wanted to, the students wanted to, and the neighborhood wanted to? The answer is no. And under the United States Constitution, you can't do that. And all of the bad things that my friend spoke about, de facto housing segregation and so on, I think it's just as bad as he thinks it is. But he wants to make it worse by dividing kids by race in the schools. That makes it worse. I want to see us treat each other as individuals. I say race is not relevant, and I say that became a part of our Constitution with the 14th Amendment, and that's the fundamental principle.
Can I?
Yeah, Professor Spece is going to weigh in on this question.
Okay. He says that he believes.
He who?
Mr. Horne. He believes that we should have a colorblind perspective in our Constitution. But the fact is that the majority of our justices would and have rejected the notion and accept that in some cases you have to look at race to make up for past issues and damages. So what he's doing, and he's trying to push this belief that he has, he keeps saying, my belief, on Arizona, the entire state, because here's what the statute says. If you advocate ethnic solidarity instead of the treatment of pupils as individuals. In other words, advocating ethnic solidarity is illegal because it doesn't adopt the colorblind approach. And I believe in the cases that I set forth do establish a derivative and institutional right that can be drawn together to support a right of the local school district on the behalf of its students and professors and the community assert a First Amendment right to control their curriculum, at least to the extent that they're not told to teach orthodoxy and return back to the 1920s.
You know, I have to say, I'm opposed to teaching orthodoxy. I'm opposed to returning to the 1920s. I'm also opposed to teaching kids that legal reasoning is toxic, that Enlightenment rationalism is toxic, that neutral principles of constitutional law is toxic. Nobody wanted to answer my question. What they don't realize
I'll be
is,
happy to answer your question.
Okay, tell me.
I want to, let me give you an example.
Richard,
let me give you an example. No, you've
Yeah, let him answer.
you've asked.
Yeah, go ahead and answer.
Let me give you an example of, I think that you are misquoting or misunderstanding, or you're taking out of context.
Here's the quote.
No, I know the quote. I've read your findings.
I was worried about the audience getting out of hand.
Let me just give one example. And I say this, let me put it in all candor here with transparency. My knowledge about this program is just a lawyer. My knowledge about this program, Mr. Horne, is because it's my family, okay? My son is one of these teachers. My son is one of these plaintiffs. My son writes curriculum in this program. He writes curriculum that is used by all the teachers, many times based on constitutional decisions, such as the Rodriguez decision. And part of where I think, and I wish you would have come to the classes, I wish you would have had a dialogue with these teachers. I wish you would have had that opportunity to share the diverging, the differences of opinion, because I think the differences of opinion are good. But I know time after time, because he's called me and asked me, can you print out certain cases so I can help, and ask me questions about teaching classes on constitutional cases where Mexican Americans were plaintiffs. And some of the organizations where there were Mexican American lawyers or MALDEF lawyers or the National Lawyers Guild or ACLU lawyers, there's been a variety of voices and legal support to the Latino community as many other communities over the years in important constitutional cases. And part of what they teach in these classes, Mr. Horne, is to understand what role we've had in the courts, that we too have been plaintiffs, that we too have contributed to the development of constitutional law, that we too are part of the 14th Amendment, that we too are part of the Equal Protection Clause, that we too challenged discrimination and got an important Supreme Court decision years before Brown. How many of you know that about Mendez? That we were there in the courts winning decisions against segregation long before Brown. That doesn't make us better. That doesn't make us superior. That doesn't make us segregationist. What it says is that we are part of the fabric. We are part of the history. And it's an important history. It is a history that includes your family. It includes Professor Spece's family. It includes Professor Atwood's family. But it also includes mine.
That's very nice, but it doesn't answer my question. The question was, this comes from the curriculum. I don't know if your son had anything to do with it, but it comes from the curriculum that rejects the very foundation of the liberal order, unlike traditional civil rights, which embraces incrementalism and step-by-step progress. This rejects the very foundation of the liberal order, including, and here are the things it rejects: equality theory, legal reasoning. I'd like the professor to tell me how he feels about rejecting legal reasoning in this curriculum. Enlightenment rationalism. Tell us call your son and let me know what's wrong with Enlightenment rationalism.
Mr. Horne.
And neutral principles of constitutional law.
Tell me a single instance in a class when any of those have been taught to students. Give me a single day, a single teacher, a single class when any of that has been stated to students.
It's in the written curriculum, and you know what, documents, the great thing about documents, they don't have memory problems, they don't lie. Documents are the best proof. This is the curriculum from the hands of the very people, I don't know if it includes your son or not.
Well,
this is the document.
Well,
if you want me to tell you what goes on in class.
I will tell you what goes on in class, sir, because I didn't have dissenters who, did sneaking and stealing of documents out of classes or secretly tape recording, taking things to your office. What I have seen and had an opportunity to participate in is a transparent, open classroom where you can go in and hear and see what is being discussed and what the students are thinking. And let me tell you something else. You have been given hundreds of thousands, tens of thousands, my understanding is over 100,000 documents. And out of over 100,000 documents, you came up with a single piece of paper that you think proves your point? I would suggest to you that you're failing to look at the other 99,000 documents, and you're also failing to really do what I would urge you to do. Because you and I are both lawyers, and we both know I can take any document just as you can take any document and argue what it means. Let me tell you where the proof in the pudding is.
I'd like you to
Don't have the courage, sir. Have the courage to come meet with these teachers. Have the courage to go into their classrooms. Have the courage to open your mind, not to prejudge them, but to go into their classrooms and talk to them and their students, not as a lawyer, not as an advocate, but as someone who says he believes in a colorblind America, as someone who says he believes in the principles of Dr. King, as someone who, doesn't object to the posters that are in the room, but says, at least can ask the question, you know what, if you have that poster up, he's not a figure necessarily I agree with. Could you at least tell me why that poster's up there? And then please go to University High, which is our gifted high school, and probably one of our most segregated high schools, and ask them and look for what posters they have in their classroom. You see, why is it that smart kids can talk about political theory and learn about Marx or Lenin and nobody questions it? But if we learn about our leaders, if we learn about our diversity of thoughts and differences of opinion, it's anti-American, or it is...
First of all, I'm sure you've read my findings, and you know I have a lot more than one page, both of curriculum materials and quotations from 6 teachers and former teachers as to what goes on in this classroom. Secondly, when you talk about posters, you're talking about Che Guevara.
That's one of them.
Che Guevara is held up as a role model in these classes. Che Guevara was a communist revolutionary advocating a system and fighting for a system that they have in Cuba, where if you have a disagreement like this we're having right now, you go to prison. I believe the people of the state of Arizona have a right to say, we don't want Che Guevara held up as a role model in our public schools that our taxpayers are supporting. And they have a right to say, we don't want the pedagogy of the oppressed by Paulo Freire, who's a well-known Brazilian Marxist. He is a Brazilian, he himself would say it. And if you read the book, you'll see constant comparisons. This is what they do in the Soviet Union. This is how things should be done. The people of the state of Arizona have a right to say in our taxpayer-supported institutions, we don't want Che Guevara as a role model, and we don't want Marxist textbooks taught to young, impressionable kids in our schools.
Okay. And sir, this is where you, I think, are being unpatriotic and un-American because you're abandoning the Constitution, you're abandoning the First Amendment. Because if you look at the First Amendment cases that deal with school settings, and Professor Spece cited some of those and read some of that text to you, this is the ongoing debate in our country, and it's a healthy debate. It's a good debate, but it's a debate that pushes back on your orthodoxy. It's a debate that says the classroom ought to be a place that is preserved to be open for diverse ideas. You may not agree with Che or what he represents symbolically, not specifically, and that's good. That's all right. And you know what? In those classrooms, those people who don't agree or have diverse opinions have that right to say it. And the teachers say it also. But also, they get to hear the divergency of ideas. And that's the beauty of the First Amendment. You know why I love this country, sir? Because of that Constitution. Because of that Bill of Rights. Because I think it was intended to cover all of us. It was intended to cover you from your philosophical perspective, but also includes mine. and that's what that Constitution protects, and that's what I embrace.
Oh, you want to?
I know you have a prior engagement.
Oh, is it time already?
Well, it's
stay
almost
with us.
7.
This
But
is so
we're,
much fun. Time has gone so fast. Let me just say, if you will read my findings, which are at azag.gov, you will have reports by 6 teachers. And I want to talk about the First Amendment now, because I want to talk about one of the very worst things that's going on in the Tucson Unified School District, something we haven't talked about yet, but I would urge you to talk to your son about. And that's the intimidation that's going on against everybody who objects to this program. Teachers and counselors, I'm quoting from a former teacher now, teachers and counselors are being called before their school principals and even the school district and accused of being racist. And with a cadre of self-acknowledged progressive political activists in the Ethnic Studies Department on the hunt, the race transgressors are multiplying. I have testimony in my findings from 6 teachers, and it's interesting how common their experiences are. When the intimidation starts, and it comes from the administration, it comes from the principals, it comes from teachers who not only call them racist, but they encourage kids to call them racist. And if any of you have been in this class, you know this is true. And the fact that they say they lose their appetites, they experience overwhelming anxiety because of the really rotten intimidation that's going on in this school district.
Well,
And you talk to me about the First Amendment.
Mr. Horne, I don't know if you had the privilege of going to the state legislature and seeing how your elected officials, your majority that passed this bill for you, treated our students who wanted to speak to them, who they told them, if you want to learn about this, do it on your own dollar. If you want to know about your history, go back to your own country. That's the kind of treatment that your elected officials, your legislators, your Mr. Huppenthal, your Mr. Pierce, who's now the Senate president, treated us. So if you want to talk about a lack of civility, if you want to talk about bullying behavior, if you want to talk about what it means to be treated as a second-class citizen, then I invite you to go to the state legislature when they take up any of our bills that are coming down on us, and we just want that opportunity to speak.
Give me one sentence, and that is, I'm not responsible. I'm not responsible.
We have the honor of having the highest ranked attorney in our state here. Please be respectful of that.
Yeah, I'm an individual. I'm not responsible for Mr. Pierce, but whatever happened there does not justify the kind of intimidation which has gone on against any teacher who dared to speak up against ethnic studies in Tucson Unified School District. And if you believe in the First Amendment, I urge you to look into that rotten intimidation that's been going on there.
folks, let me say that nobody favors intimidation on either side. I know that we all agree about that, and I think you've been great tonight. The audience has been fabulous. I don't know about the panelists, but you've been great, and thank you so much for coming. I hope it was educational.